Hello, I'm Constitutional Attorney Katherine Henry, and today is a continuation of our mini-series on 85 of the most common criminal law terms and their definitions. So to jump right back into it, rebuttal. That is the introduction of answering evidence. So it's evidence where you're responding to somebody else's evidence. It is proof by one party disputing the proof provided by their adversary and the stage of a trial in which such evidence is introduced. So it's not only called rebuttal is the type of evidence, but rebuttal is also the stage of the trial where rebuttal evidence is introduced, is what it's saying. Redirect examination. The questioning of witnesses during trial by the party that called him or her to testify, following the cross-examination by the other party on matters arising out of that cross-examination. So with redirect examination, if, let's just say I know this is the criminal video, but if it's a divorce case and I'm representing the wife, I then go up and do the direct examination. I ask my initial set of questions, which is totally open-ended as far as the kinds of things I can ask my client about. Then the husband's attorney will get up and do cross-examination and ask their type of questions. Again, they can ask whatever. They're not only limited to the subjects that I have asked my client about. They can ask about other things. However, when it's my turn to go again on redirect examination, then I'm limited in scope. I can only ask questions that were the type of topics brought up by the husband's attorney in that scenario. So redirect examination. Search and seizure. And of course, the term most commonly used is an unreasonable search or seizure. That is, in general, an unlawful search of someone's premises or person, a search that is unreasonably oppressive in its invasion of privacy and therefore would violate the Fourth Amendment to the Constitution. Search warrant. That's a written order from a judge directing an officer to search a specific place for a specific object issued on a showing of probable cause that a crime has been committed. State's evidence. Testimony of an accomplice or participant in a crime that tends to criminate or convict others, given under the promise of immunity. To turn state's evidence is the phrase that's most commonly used. Stipulation. An agreement between opposing parties or attorneys on any matter relating to the proceedings or the trial. So for example, they might have a stipulation to introduce some specific evidence at trial, or they might stipulate to certain facts just being commonly known and accepted. They might stipulate to extend the time to answer or to adjourn the trial date, things like that. Subpoena. It's an order commanding a witness to appear and testify. Summons. It's a document letting someone know that they are required to appear in court on a day named to answer for the complaint, which in this case would be a criminal complaint. Testimony. Evidence given by a competent witness under oath as distinguished from documentary evidence or evidence from other sources. Transcript. The recording of proceedings in a trial or a hearing. Very important if you ever want to appeal. Verdict. The jury's decision or finding on the issues submitted to it for determination. Voir dire. It means to speak the truth, and is typically used where the attorneys are asking questions of the pool of potential jurors to narrow down their selection of which jurors they believe would best serve on that particular case. Warrant of arrest or arrest warrant. It's an order issued by a magistrate, judge, or other competent authority to a peace officer requiring the arrest of a person named in the order. With prejudice. That means that if a case has been dismissed with prejudice, the prosecutor can never file those charges again. Without prejudice. Now, this is a dismissal where the prosecutor is allowed to refile the charges generally to just correct some procedural error that the court thinks could be remedied by allowing them to drop the initial charges and simply refile them. Witness, one who testifies to something that they have directly seen, heard, or otherwise observed.